Hello and welcome to the YouTube channel of RankersBuzz. Today we are again here with a new session, and today we will do the legal analysis of the recent judgment which has been pronounced by the Honorable Supreme Court's five-judge bench, that is the constitutional bench, in the matter of the Election Commission and with respect to the appointment of the Election Commissioner, that is the Chief Election Commissioner of India. For that appointment, this decision has been done. So before going into this judgment, let's see that what is the matter and what are the concerns over the here. So from a very long time, there has been questions on the Election Commission of India with respect to the elections, because we know that election in a democracy is the paramount thing. Election is paramount in a democracy. If it is seen that if the elections are not conducted in the fair manner, or it can be for anything, the governments may change now and then. There were previous government, there is present government, and there will be future governments, but it is important to maintain that the ECI functions, the Election Commission of India, functions in a very fair manner, and it should be equal for everyone. And a lot of times the allegations have been made. It may be true, it may be wrong, but allegations have been made. And also with respect to the criminalization of politics, a lot of question has been raised with respect to the criminal background candidates which have been projected for the elections multiple times across the party lines. No party is or no political party can say that they do not have the people from the criminal background in their assembly or in the parliament. So that is why a lot of many times many cases went to the Supreme Court, and the Supreme Court has asked multiple times to on the criminalization of politics, and a lot of times it has been said that everyone must declare their criminal antecedents, and their directions has been given, but that has also not been followed with 100% efficacy. That has also not been followed with the 100% efficacy. And then again and again, the Supreme Court has interfered into this, that the criminalization of politics is not right. But in the present matter, a lot of things have been going on since last few years, and this is a demand from last many years, that the Election Commission or the Chief Election Commissioner in the ECI must be appointed by a committee which seems to be fair. Okay, which should not be arbitrary or not within the hand of any particular agency, either it is the judiciary, executive, or legislature. It must not belong to any only one particular authority, and especially the executive, because the elections are not only for the people who are in power, but it is also for the people, every person who is living in India and citizen of India, and also for the people who are in either in power, either in opposition, or in any way part of the legislature, either it is parliament or it is the state legislature. So it is important that the elections to be conducted in fair manner, and this can only be conducted in a fair manner when the people who are responsible for taking care of this are independent, or maybe independent but seems to be independent. So such questions were raised that when it comes to the the provisions of the constitution, then there it was written in the original constitution that there should be some law which must be made for the appointment of the election commissioners, but still now no such explicit law has been there, and there was only few things which were given, that it should be the election commissioner who will take care of, or who will be responsible for the superintendence of all the elections, either it is assembly elections, either it is parliamentary elections, or president or vice president election. They are responsible for all kinds of such elections, but no explicit provision for the appointment of the election commissioners were given there. So now coming to the present case, that what is the name of this particular case? So if we talk about the name of this particular case, so the name of this case is Anu Banwal versus Union of India 2023. So this is the present case which was heard by the Constitution Bench के द्वारा जो है इनको सुना गया, because there were multiple petitions, so it was converted to one, and this was heard as a writ petition. So there were this bench was of 5 judges. Constitution bench was there, and in this judgment, the judges who were constituting the 5-judge bench, they were Justice Joseph, that is Justice K.M. Joseph, then Justice Ajay Rastogi, then Justice Aniruddha Bose, then we have Justice Rishikesh Roy, and Justice Ravi Kumar. So these were the judges who heard this particular case, this writ petition in the case of the Election Commission. So now what is the matter in this particular case? आखिर जो issue थे, what was the issue which was raised in this particular case? तो issue जो यहाँ पे raise किया गया, that was with respect to the Election Commission of India, where it was said कि भाई जो ये system है, जो system of appointment है election commissioners का, और we can say the chief election commission mainly, appointment जो है अगर हम बात करें उसको चैलेंज किया गया है अपॉइंटमेंट को, बेसिकली द ग्राउंड्स ऑफ द चैलेंज जो है बेसिकली जो है वो अपॉइंटमेंट ही है, which is it is said that it is incompatible with the provisions which is given in the constitution, incompatible with article 342 clause 2, and साथ ही साथ ये भी कहा the provision which is given is arbitrary in nature, because what is written here is that कि अभी तक जो कन्वेंशन चली आ रही है वो ये है that the chief election commissioner, chief election CEC जो है, that is chief election commissioner, he will be appointed by the president on the advice of the prime minister who is heading the council of ministers, on the advice of council of ministers headed by the prime minister. So basically if we look at this procedure which has been followed till now, so here the election commissioner is basically appointed by the ruling party itself. So there is always a doubt in the mind of people that the elections can be manipulated. It may be true, may not be true, but such suspicion can be raised, and it can be for any government. It is not specifically for the present government or previous government. It can be for any government, because in a democracy, the government keep on changing, either it is state or the central level. So that is why this question was raised not only from today, but it has been raised from a very long time, that this provision is arbitrary in nature. Such an important post on which the whole democracy is actually dependent, because this authority is actually responsible for conducting all the important elections in the country, and on the basis of this the parliament is going to be elected and making further laws. So it is important that this must not be arbitrary. So it was argued that it is arbitrary in nature, and साथ ही कहा कि भाई it is important that the CEC, that is the chief election commissioner, should be independent of any such authority which is there in power or anything, like at least from the executive it should be independent, and then only we can ensure the free and fair election. And why this has been said? Because not today, but from last many decades, we can see that there are, whenever some election happens, so there are complaints from different parts that model code of conduct has been violated, or such complaints are there. But we have seen, and the election commission is responsible for tackling all these things, but we have seen that no such action has ever been made against the people who actually do this. Very rarely election are completed, then after some months or year, the decision will come, and then it becomes infructuous. There is no meaning of taking decision after when everything has already happened. So that is why the question has always been raised. एंड साथ ही साथ कहा गया कि भाई जो यहाँ पे ये एक लैकुना दिखाई देता है, देर इज अ लेक्यूना इन दी अपॉइंटमेंट, बिकॉज अगर हम बाकी सारे जो कॉन्स्टिट्यूशनल पोस्ट है, एज दिस इज अ कॉन्स्टिट्यूशनल पोस्ट एंड इट इज इक्विवेलेंट टू एनी अदर इंडिपेंडेंट अथॉरिटी लाइक कोर्ट और एनी अदर इंडिपेंडेंट अथॉरिटी, तो कहता है यहाँ लेक्यूना ये है, अगर हम देखें सभी अपॉइंटमेंट्स को, तो सिर्फ दो जगह ऐसा है जहाँ पे कि जो है डायरेक्टली एग्जीक्यूटिव अपॉइंट कर रहे हैं, और कोई ऐसी अथॉरिटी या कोई लॉ यहाँ पे प्रोवाइड नहीं है। अब वो दो कौन से हैं? एक तो था इलेक्शन कमीशन को लेके, इलेक्शन कमीशन ऑफ इंडिया को लेके, और दूसरा जो नेशनल कमीशन फॉर शेड्यूल कास्ट है, वहां पे, जहां डायरेक्टली जो है एग्जीक्यूटिव के हाथ में होता है, एंड दे अपॉइंट दिस पोजीशन। सो ये क्वेश्चन जो है यहाँ पे रेज किए गए, जिस वजह से प्रेजेंट पिटीशन यहाँ पे आई है। नाउ अब यहाँ पे मांगी तो वैसे कई चीजें गई थी और कई चीजें सजेस्ट की गई थी, लेकिन सभी कुछ एग्जैक्टली कोर्ट मान ले ये भी पॉसिबल नहीं है, बिकॉज कोर्ट लुक इनटू द लॉ, द अवेलेबल प्रोविजंस, और उसी के तहत जो है कोर्ट यहाँ पे डिसीजन देता है। तो यहाँ पे तो कहा गया था कि भाई जो चीजें मांगी गई, जो यहाँ पे प्रे की गई, जो प्रेयर थी, अगर हम उसकी बात करें, तो इट वाज प्रेड कि भाई क्या क्या चीजें होनी चाहिए। तो 5 मेंबर कमेटी बननी चाहिए, 5 मेंबर कमेटी की बात यहाँ पे बोली गई थी, दैट 5 मेंबर कमेटी मस्ट बी गिवन, जिसके अंदर की होंगे आपके प्राइम मिनिस्टर प्लस द लीडर ऑफ ऑपोजिशन, देन द जस्टिस ऑफ इंडिया, दैट इज CGI, and plus the any eminent jurist selected by them, these above people. So this was here. अब यहाँ पे क्या क्या? प्राइम मिनिस्टर and the leader of opposition, chief justice of India, and also, sorry, here the speaker of the Lok Sabha, and a eminent jurist. So this was the the prayer कि भाई इस तरीके की कमेटी बनाई जाए, who will choose the चीफ इलेक्शन कमीशन ऑफ इंडिया। अब उसके बाद कहा गया कि इसकी क्वालिफिकेशन को भी डिफाइन किया जाए कि भाई 45 से लेकर 61 की एज के बिटवीन का आदमी होना चाहिए, हु इज बीन इलेक्टेड, एंड शुड हैव हाई मॉरल ग्राउंड्स, और ये सारी चीजें, एंड शुड बी IAS और इंडियन पुलिस सर्विस से होना चाहिए, सर्व किया होना चाहिए उसने वहां पे, एंड इनको जो है, इनकी पोस्ट जो है उसको टेन्योर जो है उसको फिक्स किया जाए कि भी उससे पहले उनको रिमूव ना किया जा सके। ठीक है, रिमूवल जो है वो इतना इजी ना रहे, और साथ ही इनके लिए एक इंडिपेंडेंट सेक्रेटेरिएट की व्यवस्था हो, क्योंकि वी नो दैट लॉट ऑफ वर्कलोड इज देयर, तो उनको देखने के लिए जो है इंडिपेंडेंट सेक्रेटेरिएट का होना जरूरी है। विल लुक इनटू द मैटर्स, लाइक वी नो दैट लोकसभा हो, राज्यसभा हो, उनके लिए भी अपने अपने सेक्रेटेरिएट है, बिकॉज बहुत सारे काम होते हैं विच इज नॉट पॉसिबल विदाउट हैविंग अ गुड नंबर ऑफ स्टाफ एंड दी अप्रोप्रिएट जो सारी चीजें चाहिए वो उसके अंदर होनी चाहिए। तो सेक्रेटेरिएट इज इम्पॉर्टेंट, एंड जो इसका एक्सपेंसेस हैं, जो भी एक्सपेंसेस हैं ECI के, जितना भी खर्चा है या जो भी चीज़ें इनको ज़रूरत पड़ती है, उसके लिए ये सिर्फ जो है हमेशा जो रूलिंग पार्टी है उसके ऊपर डिपेंडेंट ना रहे, बल्कि इनके लिए जो है प्रावधान किया जाए दैट द फंड्स मस्ट बी टेकन फ्रॉम दी CFI, कंसोलिडेटेड फंड ऑफ इंडिया से डायरेक्टली यहाँ पे फंड आना चाहिए, जैसे कि सुप्रीम कोर्ट, CAG, या जैसे कि UPSC, इन सब के लिए जिस तरीके से फंड का एलोकेशन किया जाता है वन टाइम, उस तरीके से इसके लिए भी किया जाए, ना कि ये हमेशा जो है विम्स एंड फैंसीज ऑफ जो है सेंट्रल गवर्नमेंट वो रहे कि हमेशा जो है इनको हर चीज़ के लिए उनकी तरफ देखना पड़े, ये ना हो। इनके लिए जैसे सुप्रीम कोर्ट, यूपीएससी या सीएजी, इनके लिए फंड की व्यवस्था है कंसोलिडेटेड फंड ऑफ इंडिया से, वहां से ही इनको फंड दिया जाए। सो ये तो कुछ चीजें थी जो उन्होंने सजेस्ट की। नाउ इट वाज अप टू दी सुप्रीम कोर्ट टू लुक इनटू द मैटर एंड डिसाइड कि भाई व्हाट आर द थिंग्स दैट आर नेसेसरी टू बी गिवन, क्या क्या चीजें जो हैं वो देनी चाहिए। तो सुप्रीम कोर्ट ने यहाँ पे जो सबसे इम्पोर्टेंट चीजें कही, जो बेसिकली जिसको हम कहेंगे जो सुप्रीम कोर्ट का यहाँ पे ऑर्डर है, अगर उसको हम देखें तो वी कैन से क्या क्या चीजें सुप्रीम कोर्ट ने कही। सबसे पहले तो बात की अपॉइंटमेंट की, एंड अबाउट अपॉइंटमेंट इट सेड कि भाई अपॉइंटमेंट किस तरीके से होगा। तो अपॉइंटमेंट के लिए बोला दैट देयर विल बी अ 3 members कमिटी। ठीक है, 3 मेंबर की कमिटी होगी विच विल कंप्राइज ऑफ द प्राइम मिनिस्टर ऑफ इंडिया, दैट इज पीएम, देन द लीडर ऑफ ऑपोजिशन और द लार्जेस्ट पार्टी के जो लीडर हैं इन द लोकसभा, then the Chief Justice of India. These three will comprise this committee and they will advise on the name. ठीक है, they will select the name of the person who will be appointed as Chief Election Commissioner of India, and the President will further appoint that person as Chief Election Commissioner. ठीक है, तो यहाँ पे जो अपॉइंटमेंट करेगी वो ये कमेटी करेगी। और ये कहते हुए जो है इन्होंने ये कहा, ये ऑर्डर देते हुए दैट जब हम अगर कॉन्स्टिट्यूशन के इनिशियल प्रोविजंस को देखें, the forefathers of this constitution had envisioned that there must be some law, क्योंकि उसमें लिखा हुआ है that the parliament should make a law, और आज तक वो नहीं बनाया गया जो कि विजन था। तो सुप्रीम कोर्ट ने बोला ये 3 member कमेटी का जो प्रोविजन है या जो हम बोल रहे हैं, इट इज नॉट परमानेंट दैट वी आर मेकिंग लॉ बिकॉज दिस इज नॉट आवर अथॉरिटी, बट as it is public demand and till the time there is no law, ultimately it is the responsibility of the of the parliament to make the law. So till the time there is no law in place, ये चीज फॉलो होगी, एंड व्हेन द लॉ इज मेड, जब लॉ बन जाएगा, पार्लियामेंट अप्रोप्रिएटली लॉ बना देगी, देन लॉ विल प्रिवेल ओवर दिस पर्टिकुलर डायरेक्शन विच हैज बीन गिवन बाय द ऑनरेबल सुप्रीम कोर्ट राइट नाउ। अभी जो डायरेक्शन दिया है हमने कमेटी बनाने का, ये डायरेक्शन नहीं, वो फॉलो किया जाएगा। साथ ही जैसे कि मैंने आपको बताया फंड्स को लेके या फिर सेक्रेटेरिएट को लेके जो है यहाँ पे कुछ चीजें बताई कोर्ट ने। अब उसमें क्या बताया यहाँ पे दैट जो केंद्र सरकार है या जो गवर्नमेंट है वो सेक्रेटेरिएट बनाए, देयर शुड बी अ सेक्रेटेरिएट टू यू नो, एक सेक्रेटेरिएट बनाया जाए जो कि लुक आफ्टर करे सभी चीज़ों को, इलेक्शन कमीशन ऑफ इंडिया को। देन बात की गई फंड्स की कि भाई फंड्स किस तरीके से दिए गए, तो इसके अंदर बोला गया इस तरीके का प्रोविजन किया जाए दैट दे मस्ट बी गिवन दी फंड फ्रॉम दी कंसोलिडेटेड फंड ऑफ इंडिया, जिस तरीके से बजट में एलोकेशन होता है किसके लिए होता है, जैसे कि सुप्रीम कोर्ट के लिए होता है, सीएजी के लिए होता है, कंट्रोलर एंड ऑडिटर जनरल, या फिर यूपीएससी या और अथॉरिटीज के लिए होता है। इसी तरीके से इनके लिए भी फंड का इंतजाम किया जाए, ना कि ये हमेशा जो है वो सेंट्रल गवर्नमेंट के तरफ देखे जब भी इन्हें फंड की जरूरत पड़े। तो ये इनकी डिपेंडेंसी नहीं होनी चाहिए किसी के ऊपर, ये पूरी तरीके से इंडिपेंडेंट दिखने चाहिए। फिर साथ ही साथ यहाँ पे क्रिमिनलाइजेशन ऑफ पॉलिटिक्स का जिक्र भी जो है सुप्रीम कोर्ट करता है और कहता है कि भी रिमूवल के लिए भी, जब रिमूवल की बात हुई तो इनको वही प्रोटेक्शन मिलनी चाहिए, सेम प्रोटेक्शन एज सुप्रीम कोर्ट जजेस, कि भी ऐसा ना हो कि भी जब सरकार चाहे तो हटा दे, चाहे वो कोई भी पावर में हो, तो ये नहीं होना चाहिए बिकॉज दिस इज अ इंडिपेंडेंट अथॉरिटी। So they must be given the similar kind of protection which is given to the Supreme Court judges. Similarly, ये भी कहा गया they must complete their tenure. जो tenure है must be completed. ऐसा नहीं that they will be removed every now and then. They must complete the tenure so that they can work independently and they must not have pressure from any kind. ठीक है, किसी भी तरीके का प्रेशर जो है इनके ऊपर नहीं होना चाहिए। तो ये कुछ बातें जो है यहाँ पे कोर्ट ने कही। तो अगर हम इसको तो इसमें है, कई लोगों का ये भी कहना हो सकता है दैट द गवर्नमेंट हैज ओवर रीच्ड दिस थिंग। some people can say that it is a overreach, but as we know, this argument may be made, इस तरीके की चीज can be made, but when we look at as per the the law and the things which is written in the constitution, then when it comes to the Supreme Court, we call it the guardian of the constitution. So whenever there is any need to safeguard the provisions like democracy or rule of law or anything like that, it is the responsibility of the Supreme Court to safeguard each and every provision like that. So that is why it was important, and it is not for the very first time that Supreme Court has done this. Whenever the Supreme Court waits for a very long time before doing this, as in this case, it was written in the initial constitution that such law must be made. But since last many decades, no such action has been taken by the respective governments. No government has taken the action, and they have taken benefit, may have taken benefit of this also कि भी उनके हाथ में पावर रहे. एंड इफ अगर हम देखें, जब भी सुप्रीम कोर्ट को लगता है दैट नो सच लॉ इज अवेलेबल इन certain part, like in the case of Vishakha, as we know about the Vishakha guidelines which were issued in 1997. And why it was issued? It was also a domain of parliament, but why it was issued? Because at that point of time, there was no available law to safeguard the women at the workplace. There was no such provision. That is why the Supreme Court issued these guidelines. And along with that said, कि till the time the parliament doesn't make a law, this will be applicable. And when the parliament will make law, that law made by the parliament will prevail over these guidelines. ये guideline खत्म हो जाएंगी और law जो है वो applicable हो जाएगा. But unfortunately, we have seen the governments, take a lot of time. Governments change, but they do not make laws on such sensitive issues. Like we can say that ये अगर इसकी बात करें तो भी it took many years, and it was only in the 2012 when this after this Vishakha guideline, the POSH Act was introduced in the parliament and passed. So it took many years, even though governments have changed. We cannot blame one government or two government. No governments took note of that. And in 2012 only, this law was made on the Vishakha guideline. So we cannot say that this is actually overreach, but to safeguard the the basic structure of the constitution. And that is, the democracy is part of the basic structure. So it is the responsibility of the government, the Supreme Court, to take this step forward and tell or suggest the parliament to make laws on such relevant issues. So we can say that this is not overreach, but it is within the law and within the power of the Supreme Court, and it has already been done in many cases. This is not for the very first time that this has been done, because we have seen the governments are lazy enough to act on certain sensitive issues, and a lot of time the Supreme Court has interfered into this. And it is not actually interfering and obliging you to follow this, but they have said that till the time you don't make a law on this. Once you make a law, you can make law now or then, anytime you want. And when this law will be made, this will prevail over the Supreme Court's order. So now it is up to the governments to or the parliament to make the law and just get out of this particular order. So this was about this particular judgment. So it is important to know with respect to the examination, because now this judgment has came. So there is a very high probability that questions related to ECI may be asked in different examination. Either it is any law examination or SSC, UPSC, or any examination. This question can be asked, that which committee or the committee comprises of what. दिस कमिटी के बारे में जो है आपसे पूछा जा सकता है किसी भी एग्जामिनेशन में. यू मस्ट रिमेंबर इट इज अ 3-member कमिटी and is comprised of PM, LOP, and CGI. So this is very, very important with respect to the upcoming examination and otherwise also. Okay. And definitely it is for sure that this will be asked in the near future. जो भी पेपर होने वाले हैं उसमें 110% ये questions पूछे जाएंगे, because this is a very landmark judgment pronounced by the constitution bench. खासकर जब भी कोई डिसीजन कॉन्स्टिट्यूशन बेंच के द्वारा सुनाया जाता है वो वैसे भी इंपॉर्टेंट हो जाता है, because we know that constitution benches take matters after very long time and only very important specific matters are taken up by the constitution benches. Otherwise तो डिवीजन बेंच में केसेस जाते हैं और सॉल्व होते हैं, लेकिन कॉन्स्टिट्यूशन बेंच अगर सुन रहा है तो डेफिनेटली इट इज इंपॉर्टेंट एंड सम डिसीजन हैज बीन टेकन, सो इट बिकम्स वेरी वेरी इंपॉर्टेंट फॉर अस टू रिमेंबर. I hope you all have understood the legal point of view which is there in this particular judgment. So I hope you will keep continuing to watch our videos and subscribe our channel to get more updates in the near future. Thank you so much. Good night. Take care. Bye bye everyone.